All right, sir, are you Cameron Spencer?
Yes.
Okay. Are you able to hear me okay?
Yep.
Go on the record now. People versus Spencer. This is file number 255404. The record should reflect Mr. Spencer's present today by video from Department of Corrections. If I could have counsel put your appearances on.
Sierra Coke on behalf of the people.
Michael Ferrone on behalf of Mr. Spencer.
We're on the record today for, excuse me, a hearing on defendant's motion for resentencing. Mr. Ferrone, I did receive your motion and brief. I had a chance to review that along with the file generally. Ms. Koch, I did receive your response. I had an opportunity to review that as well. Mr. Ferrone, was there anything that you wanted to present today by way of oral argument?
Yes, just briefly. First, thank you for letting me appear via Zoom. I did also receive the prosecution's response. I appreciate their getting that to me in a timely way. It's still our position that OV12 was misscored. Mr. Spencer, my understanding, was rejected by a girlfriend, and then he did something to a dryer which started a fire in the new boyfriend's home. That's a serious matter, hence the charges. At sentencing, he was scored 25 points for 3 or more contemporaneous felonious criminal acts involving crimes against a person that will not result in a conviction. And OV12 is scored for acts, not, you can take an act, and it's very easy to take an act and divide it up into different charges. Especially when there's more than one victim, it becomes even easier. But under People v. Light, the variable scored for acts. So in this case, we have the dismissed home invasion. That could be scored. That's a separate act. So that's one. The dismissed intent to murder counts cannot be scored because they involve the same act as the arson. I haven't seen any suggestion to the contrary. It's the whatever Mr. Spencer did to the dryer, that's the actus reus of all of those convictions and dismissed charges. So same act meaning you can't score it under OV12. What about the dismissed property damage charges? No, again, because it's the same act. It's the same act, whatever he did with the dryer, caused the property damage, caused a variety of things, but one act, therefore, can't be scored. What about the dismissed, the slashing of tires? I hadn't thought about that. I don't know that a charge is brought on that. Now, that's a separate act. So there, the prosecution does not have that problem. That would be a separate act. However, it's not a crime against a person. So it's a property damage crime. So it could get us to 10 points, but it can't get us to 25. That's just a matter of statutory language. When we look at the statute, 25 points requires 3 or more crimes against a person. When you get down to 10 points, you can do that with 10 points, 2 crimes against a person, or 3 or more other crimes. So the slash of tires could be scored, but it won't get us to 25 points. The same is true of the lying to police, which I take to mean perjury, a claim that Mr. Spencer engaged in perjury. Assuming, this is true of the slash of tires also, they would have to convince the court by preponderance of the evidence that occurred. But assuming all those things, can be done, it's a public trust crime. It's not a crime against a person. So if you took the home invasion, added it to the slash of tires, added it to the perjury, you could have 3 or more other crimes. That would be 10 points. And at 10 points rather than 25, the guidelines still change. And so it's our position that a resentencing would be required.
All right, thank you. Ms. Koch, anything in response?
I would just say that there were a multitude of crimes. He stalked her. He went to the house. He went inside the house. He sat for an hour in waiting. He prepared to burn the house. He came up with plans to burn the house. He started the fire while the people were sleeping in the house. He leaves. He slashes the tires. He uses his phone, which is using a computer, to call his mom to tell her to lie to the police. He plans to lie to the police. He comes back to the house and watches the house burn, and then leaves and then lies to the police during the investigation. We went through a pretty thorough sentencing. There's lots of OVs. We heard from the victims and all the things that happened. One of those victims has since died. He was never able to move back into his home. And so he couldn't testify or be here today, but I think the court got it right. And I would ask the court to uphold the sentencing. Thank you.
Thank you. Mr. Ferone, it's your motion. Anything that you wanted to state in response?
Well, prosecution's thrown out a couple new theories. Stalking. I don't know if he stalked anyone, but assuming he did, I think that would be a misdemeanor in this case, given that, he didn't have a record. It doesn't sound like they're alleging aggravated stalking. They didn't charge aggravated stalking. So again, there's a lot of factors that have to be met to score this variable. One of them is that it has to be felonious conduct. Watching the house burn. What felony does that? I don't think that's a felony. So I think they brought all the charges that they could have brought. To be honest with you, I'm skeptical that they had a slashing of tires. I'm skeptical that they had a perjury. Perjury is very difficult to prove. I think if they felt they could have proved it, they would have brought it. I think they brought all the charges that they could have brought, and I've already addressed them. And for those reasons, I think the guidelines fall. The existing sentence actually falls outside the correct guidelines range. And I think that's a problem. And I think we have to unfortunately, you have to do a resentencing. Thank you.
All right. Again, I did have an opportunity to review all the written arguments and briefs. Those were consistent with what counsel's argued more or less here on the record today. In order to score OB12, the court has to find at the level scored here for Mr. Spencer, the court would have to find 3 contemporaneous felonious acts. They would have to occur within 24 hours of the sentencing offense and not result in a separate conviction. The operative, I think one of the interpretations that I find particularly relevant or operative in this case for OB12 is that the court has to look beyond the sentencing offense and consider only those separate acts or behavior that did not establish the sentencing offense. And I think that's key here. It's kind of a nebulous concept, and I always find OB12, I think, a little bit difficult when you're dealing with acts or behavior that are kind of intertwined with the sentencing offense, because I don't think the statutory language gives us real good guidance, and I think even attempts by appellate courts to interpret that language doesn't give real great guidance either. I just think it's a difficult concept to try to separate out behavior that is, I want to say concurrent or mixed in with the sentencing offense, and separate acts or behavior that could be scored under OB12. So it's a difficult concept. And I think Mr. Ferone certainly raises a lot of good points with regard to the attempted murder offenses here, which I think are the ones that really the court can consider, and the only ones. The prosecution raises all kinds of other acts that, some of which there may be very good evidentiary support for, but I don't know that they would qualify as felonies, as contemporaneous, or as crimes against a person. So I think in my review, and from even a preponderance evidentiary standard, I think the court is limited to looking at just the attempted murder offenses as contemporaneous felonious acts directed at a person. So the question here, I think Mr. Ferone correctly points out that the question here is whether those would qualify under OB12. And while I agree with Mr. Ferone's analysis that it has to be only those separate acts or behavior separate from the sentencing or beyond the sentencing offense, there is that added language that says that did not establish the sentencing offense. And I think that's, to me, the key here, and perhaps an appellate court may see it differently than I do, and that's fine. But my review of that evidence, or that language, is that it's acts or conduct that are separate from the sentencing offense and couldn't have been used to establish the sentencing offense. And so when you look at second-degree arson in this case, none of the elements of second-degree arson, looking at the standard criminal jury instruction, involve requirement that the dwelling be occupied, that the defendant create a risk of injury or risk of death. There's no requirement in the elements of second-degree arson that there's an intent to cause serious injury or death and those types of things. It just has to be essentially the burning of the dwelling. So when I think of what it takes for arson to be established and what it takes for attempted murder, they are different acts and different behavior. And I mean, there is a connection in this case because the act or behavior that the defendant committed arson, that would have taken to its unfortunate conclusion, which didn't happen in this case, could have resulted in death or serious physical injury to one of the occupants of the home. Those aren't elements that are required for arson. So in my view, in looking at that language, they are separate. It is behavior. The fact that he engaged in that conduct with people present that could have resulted in the death of those people or serious physical injury, that's behavior that's beyond what would have been required to establish second-degree arson, the sentencing offense. And so for that reason, I find that this is separate behavior or acts or conduct that wouldn't have been necessary to establish arson, but could have established murder or attempted murder. So I find that OV 12 was properly scored with regard, and I think that's equally applicable to the home invasion. So I find that OV 12 was properly scored for those reasons. Again, I think it's a fairly fine line. I think it's possible that how the court could have a different interpretation, but that's the way I view it. And so for that reason, the court is going to deny the motion. And Mr. Ferrone, I would just request that you prepare an order and submit that to the court for signing.
That's not a problem, Your Honor. I can, I'll have that out. Unfortunately, I'm going to be out of town for the rest of this week, so it may come in a little bit later than it normally would, but I will get an order submitted. Thank you.
Your Honor, can you check and see if there's one on the back of my response? I almost always do one.
Oh, there is.
Okay.
Mr.
Great.
Ferrone, I don't know.
It's just a blank, granted or denied.
Ms. Koch submitted an order. I don't know if you have that with your materials. If you don't have a problem with regard to form, I can sign that right now.
I have no problem with the form, Your Honor. Thank you.
Yeah, I think we just need to change the judge's name, that's all.
Okay.
Thank you.
I'll make that correction. Okay, Mr. Ferrone, anything else that we needed to address for the record today?
No, thank you for your time, Your Honor. Appreciate it.
Ms. Koch?
No, thank you, Your Honor.
Okay, Mr. Ferrone, you're free to disconnect, and Mr. Spencer, we're going to disconnect from your facility as well.
Okay.
Mr. Ackerman?
I expected to hear it, Your Honor. I saw him this morning. He was at my office. Travis?
All right, we're on the record in People versus Ackerman, file number 245312. If I could counsel put your appearances on.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Jason Thompson on behalf of defendant Travis Ackerman.
Okay, this hearing was set for 1:30. It's now 1:49. Mr. Ackerman's not present. Mr. Thompson, can you just make the record of your contacts with him?
Yes, Mr. Ackerman was released last week. He was at my office first thing in the morning. We talked about this hearing. I expected him at the courthouse at 1. I'm not sure where he is. I'm gonna have my staff call him.
Okay. I'm gonna pass this for now. If Mr. Ackerman doesn't hear, I will report stack it this afternoon. I'll case with that then.
Thank you, Your Honor.
People versus Poirer, file number 255471.
Sheriff Hope on behalf of the people.
Mr. Poyer, if you can just come right to the podium there, please. That should reflect Mr. Poyer is present here in the courtroom today.
We are here today for status conference. We do have an offer from the prosecutor, which we would seek to take advantage of. That offer contemplates an admission to the domestic violence offense, which is a lead count for 2.
Got that as count 1.
With a dismissal of habitual fourth offender notice. As well as the resisting instruction.
That is a correct statement of the offer. It was a plea to domestic violence, third offense, dismiss the habitual, dismiss the RNO.
Just for the record, I just want to make sure we're correct. I have the information as a third offense is being dismissed.
And Your Honor, I apologize. I think from the felony complaint to the felony information, there's some differences.
Changed, okay.
So it would be count 1 with a dismissal of the habitual offender. As well as count 2. So that would contemplate a plea to the 5-year felony. That would be a no contest plea, and I have the interim complaint, an affidavit for the court in terms of factual basis.
And Ms. Coe, do you have an objection to the no contest plea?
No.
What is the basis for the no contest?
Your Honor, Mr. Poyer has a long history of mental health issues, which frankly, we're going to address to the court a little bit later in the hearing. He does not have a clear recollection of everything that happened.
Ms. Coe, do you have any reason to object to the basis for the no contest plea?
No.
Mr. Poyer, have you had an adequate opportunity to speak with your attorney about this plea agreement?
Yes, sir.
Is that how you wanted to proceed today?
Yes, sir.
Raise your right hand, please. Solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
You can lower your hand. Mr. Poyer, are you currently on any kind of probation or parole?
No, sir.
You understand that by pleading guilty to, no contest to domestic violence third offense, that the maximum possible penalty you can face would be up to 5 years or a $5,000 fine.
Yes, sir.
With that in mind, what is your plea for that charge today?
No contest.
All right, I'm gonna go through your rights with you. Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you. Right to testify yourself at a trial if you want it. You understand all those rights. You understand you're going to be giving up and waiving all of those rights by pleading no contest.
Yes, sir.
Also, you don't have an automatic right to appeal the plea that you're making today or to try to get it reversed. Wanted to try to do that, you would have to ask for the Court of Appeals to hear your case. If they said no, then that would be the end of any appeal. You understand?
Yes, sir.
Has anyone threatened you with anything to get you to plead guilty?
No, sir.
Has anybody promised you anything other than what we've said here in court?
No, sir.
Your own free choice to enter this.
Yes, sir.
Right. Can you read, the complaint and affidavit?
I have.
Information contained within there which provide a factual basis for finding that the defendant is charged.
Yes.
Sure, should be done that as well.
I have.
Would you agree that it would provide a factual basis?
Yes.
I would.
Ms. Koch, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No,
Mr. Truitt, are you?
No, but I do, before we go any further, I do think we probably need to ask him about the prior offenses, the prior domestic violence offenses.
Mr. Poirier, were you previously convicted of domestic violence back in 2013 in District Court in Roscommon County?
Yes, sir, sounds good.
And then also in 2017, also in Roscommon?
As possible. Sir,
If the records indicate that, do you have any reason to doubt that?
no, sir.
Mr. Truitt, with that,
I think that we would have a factual basis.
Mr. Truitt, are you aware of any threats, promises, or inducements other than what's been placed on the record?
No,
And both counsel, are you both satisfied that the court has complied with statute and court rule in the taking of this no contest plea?
yes, Your Honor.
I am satisfied.
Mr. Poirier, the court finds that your plea is knowing, voluntary. I'm going to mark that complaint and affidavit as court exhibit 1 and admit that as evidence in the file. Court has reviewed that. I'm satisfied based on information contained within court exhibit 1 that it would establish a factual basis that you are guilty of this charge. The court will accept your no contest plea. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. Between now and then, someone from the probation department is going to meet with you for a pre-sentence report. You'll have a chance to go through that with Mr. Truitt prior to the sentencing hearing. Mr. Truitt, anything else we need to address with the record today?
Yes, Your Honor, I did want to address bond. I have a few documents for the court. I'm providing the same to the prosecutor. The first is a letter from his counselor, Mr. Gant, who he was seeing at the time of this event. The second is going to be a message from Mr. Gant, a text message from Mr. Gant to Mr. Poirier, basically identifying that his depression, anxiety, and ADHD were out of control, and that that basically every time that Mr. Gant had seen him change medications. The third document is a diversion plan from CMH, signed by both the CMH jail specialist as well as Mr. Poirier. I'm going to provide all those to the court. Okay. Once the court's had an opportunity to review them, I'll address it directly. So, Your Honor, I would ask court to consider amending the bond to allow Mr. Poirier to be released, specifically to be released and follow the diversion program that's been created by CMH. Obviously, from our perspective, the opportunity to show the court that the diversion plan is viable and working prior to sentencing would be very valuable, but I think at a fundamental level, Mr. Poirier being in the jail is somewhat of a disservice, and he has significant mental health issues. Certainly, I understand, and I know the prosecutor is going to say that there's history here, and there certainly is. We don't deny that. But he has significant mental health issues. At the time that this occurred, he was seeing Mr. Gant, but frankly, it was essentially a teledoc situation, meaning he was not meeting him in person. Everything was being done either telephonically or via Zoom. Frankly, based on what the jail staff and CMH are indicating, it sounds like Mr. Poirier was being over-medicated at the time, which we all know can create just as many problems as being under-medicated. they were working off of a psychological assessment that was frankly 5+ years old at the time. I really think that Mr. Poyer is someone who, with the proper mental health intervention, can be a successful member of society, but I think it's got, one, for his type of issues, I think it's got to be face-to-face. I can appreciate how teleconferencing technology is helpful for all sorts of things. I don't see how it can be effective for this type of situation. So I would ask court to consider modifying the bond or reinstating the bond, I should probably say, so that he could participate in that program, be able to show the court that not only is this plan viable and effective, but he could comply with it given the opportunity to. Thank you.
Let's go.
Your Honor, I would absolutely disagree. For one, Mr. Porter has a bad attendance record. And I believe it was indicated he has some type of thing where he won't come in public. But when you look at his criminal history, which is very assaultive, it's a long assaultive history. It involves egg stalking, several DVs, UDAA. There's some pretty serious juvenile cases in there. He had an assault by strangulation. It looks to me, when I look at his criminal history, that he went to prison for that in 2017. I don't know when he was released because it doesn't say. While he was on bond, he broke into a building in town. When this happened, his parents, who I've had a talk with just recently, called me and told me that I thought he was going to kill him. This issue with this medication is ongoing. It's been ongoing for a long time. When I looked back at his 2016 PSI from another violent offense, he talks about he was off his medication then. The follow through with his medication, his mental health is an ongoing issue, as is his alcoholism. I don't think, given his long assaultive history, that this is appropriate. I'd ask the court to continue. Thank you.
All right, based on the seriousness of the underlying charge, the fact that we have a no contest plea, and the fact that the basis for the plea was that Mr. Poyer was either intoxicated, which is indicates a blood alcohol level of 0.20, which is quite high, or was undergoing some type of mental health crisis where he doesn't remember engaging in this activity, that gives me some serious concern for public safety. And given his prior failure to appear, the court finds that bond is appropriately set, and the court is going to leave bond where it is. Mr. Poyer, I'm going to get a lot more information through the pre-sentence report and sentencing that might help guide me a little bit in terms of what we do in terms of treatment for you for your mental health issues. But in terms of a bond issue right now, the court is going to deny the request to modify it. Did you want these made part of the file, Mr. Drew? Or did you want them back?
Yeah, the court can hold them. I mean, I may wind up providing copies to as an attachment to the PSI. But
All right. Where, jury box. Mr. Vogler present. Versus Vogler, file number 255500. The record to reflect Mr. Vogler is present in the courtroom today.
Here, Cook on behalf of the people.
Your Honor, Richard Trush appearing on behalf of Mr. Vogler.
Tell me the status of this file.
Yes, Your Honor. We are in receipt of an offer from the prosecutor's office. The court may recall when we were at the last hearing, we had indicated we had a offer from the prosecutor's office. It was something that we were inclined to accept. But I had just become aware that he had charges, I think, over in Kalkaska County that Mr. Seeger represented him on. I've been in contact with Mr. Seeger. We're working on trying to get that resolved with Kalkaska as well. But at this time, we would be prepared to take advantage of the offer tendered in this file, which contemplates that he would tender a plea to count 1, the possession of methamphetamine. Count 2 and 3 would be dismissed, and the prosecutor would not object to 7411 if he is eligible for it.
So is that a correct statement of the plea offer?
It is. I don't know with his other things going on, whether or not he is eligible or not, but if he is eligible, we don't object. That's getting 7411 is not part of the plea at this point, but our position to not object is.
Mr. Vogler, have you had an adequate opportunity to talk to your lawyer about this plea agreement?
Yes.
Is that how you wanted to proceed today?
Yes.
Can you raise your right hand, please? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. Thank you. Mr. Vogler, are you currently on any kind of probation or parole?
No, sir.
You understand that by pleading guilty to count 1, which is possession of methamphetamine, that the maximum possible penalty you could face would be up to 10 years and or a $15,000 fine?
Yes.
Need any more time to talk to Mr. Trudeau? With that in mind, then what is your plea to that charge today?
Guilty, Your Honor.
Right now, you have certain rights. I'm gonna go through those with you. You have the right to have a trial. You have the right to be tried by jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you here at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf here at trial. You have the right to remain silent during a trial, to not have that silence used against you, and the right to testify at a trial yourself if you want it. You understand all those rights.
Yes, sir.
You understand that you're giving up and waiving all of those rights by pleading guilty.
Yes.
Also, you don't have an automatic right to appeal the plea that you're making here today. You did want to try to appeal it, you have to ask for the Court of Appeals to hear your case. If they said no, then that would be the end of that appeal. You understand that?
Yes, sir.
Has anyone threatened you with anything to get you to plea guilty?
No, sir.
Has anybody promised you anything other than what we said here in court today?
No, sir.
Is it your own free choice to enter this plea?
Yes, sir.
Are you pleading guilty to this charge because you are actually guilty?
Yes.
This happened back on July 25th of 2025. Is that the correct date?
Yes.
Okay. On that day, were you present here in Crawford County?
Yes.
While you were here in Crawford County, did you have possession of some methamphetamine?
Yes, not possession of a pipe.
No, sir. And did that pipe have some methamphetamine?
Yes.
Okay. Did you know that that had some methamphetamine?
I did.
Did you have any legal right to have any amount of methamphetamine?
I did not.
Ms. Koch, are the people satisfied with the factual basis?
Yes.
There is a factual basis.
Counsel, are either of you aware of any threats, promises, or inducements other than what's been placed on the record?
No.
I'm aware of none.
Are you both satisfied that the court has complied with statute and court rule on the taking of this plea?
Yes, Your Honor.
Yeah, sure.
Mr. Vogler, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. And somebody from the probation department is going to be in touch with you to do a pre-sentence report. And you'll have a chance to go through that with Mr. Church prior to the sentencing. Spoken anything further on this file today?
No, thank you, Your Honor.
Your Honor, I think at the last hearing, because Mr. Vogler was lodged in Kalkaska County, we had voluntarily asked to have his bond canceled so he could earn credit. Mr. Vogler identified to me today that he's been accepted into a treatment program. I don't know that he's been allowed that. Kalkaska has amended his bond yet, but given the circumstances, I would ask court to consider reinstating his bond. Again, I don't think he's done anything to suggest that he's not a good candidate for bond. We just asked to have it canceled previously so he can earn credit.
So
That is correct. They voluntarily canceled the bond. If he wants to reinstate the bond, I obviously wouldn't object. I'm not sure what the other two counties are doing. So it may be a moot point, but I don't object.
okay, I think that's appropriate. So the court will reinstate bond under terms and conditions previously set by the court.
Just so I'm clear, does the court want me to prepare an order to that effect?
Yes, please.
Understood.
Okay, thank you. People versus Donegan, file number 255510.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Patricia Perry on behalf of Mr. Donovan.
Mr. Donegan, come right up to the podium here. Please.
That's
Oh,
Mr.
sorry.
Michelle's.
Mr. Donegan probably is not going to be present. He was writted here from Macomb County. The jail didn't go get him because they thought we had switched it to a telephone, but a writ wasn't done to telephone. We contacted Macomb Jail and asked them if they could do it by phone. This morning, when I found out that the writ had been canceled, they indicated they could not accommodate that. We sent the request anyway to ask whether or not they could do the telephonic appearance, and we did not get a response.
Your Honor, that I think that's largely accurate, and I think I probably have to fall on my sword here. The circumstances were this was ordered to be in person because I had difficulty communicating with Mr. Donegan. I had made arrangements and went down and met with him in the Macomb County Jail on Friday. While making those arrangements, I was in communications with the prosecutor as well as the county jail here. I think everybody knew that I was going down there. We let the jail administrator, Ms. Tessner, know after I had met with him that he wouldn't need to be picked up. In all of that exchange, I think it got lost that we would still need him here telephonically. Again, I think that probably falls on me, so.
Okay. If we reset this for 2 weeks, is that gonna be enough time to secure his appearance at this point?
Yes.
And that, I think that should be fine. I would indicate just so the court is aware, we are in receipt of an offer that we intended to take advantage of via a no contest plea.
Okay.
So just so the court has some idea of this.
All right, I don't know if we can get it on for the March full day. If we can, we will. If not, then we'll set it for the mid-March day. So have you had discussions with the victim about the no contest plea in this case?
We have had discussions with the victim, lots of them, about the plea. I don't foresee an issue with it.
I guess I'm gonna ask counsel to, prior to that next hearing, whenever that is, 2 weeks or a month, you could go, or one of you submit to the court the terms of the plea agreement as well as the reason for the no contest plea. I'm always hesitant to enter no contest plea in a case like this. So I mean, so. Terms of the plea offer.
Yes, Your Honor.
Okay. All right, thank you. That's all for this hearing. What's your other client there,
Mr. Michelle's.
Michelle's? Okay, Mr. Michelle, if you want to move forward, please. On the record, in People versus Michelle, this is file number 255502. I get counsel to your appearance.
Christopher Dyer on behalf of the people, Your Honor.
Thank you, Your Honor. Richard Trish on behalf of Mr.
And this is the date and time set for sentencing in this matter. Mr. Michelle, so we had a chance to go through the pre-sentence report. Mr. Trish, I did receive a report from pretrial services indicating that Mr. Michelle has complied with testing and has otherwise been in compliance with these conditions.
I did receive that, Your Honor.
I have seen that.
So my only concern is 2 weeks ago, he did not appear, and I think there's a bench warrant for him in district court. I don't know if he's taken care of that.
I
don't know.
It was the driving while license suspended. You were in court that day. I was on Zoom. So there might be an open warrant. I haven't gotten a new date on it. I'm assuming there was several driving while license suspended. I'm not sure if he just didn't know.
Yeah. We'll go forward with this hearing.
Yeah, I just so he could take care of it while he's here. I thought that would probably be appropriate.
Absolutely. Okay. Mr. Truce, are there any additions, deletions, or corrections to the PSI?
No, Your Honor.
Any challenges to the scoring?
No, Your Honor.
Mr. Gregor, any additions, deletions, or corrections?
No, and no challenges to the scoring, Your Honor.
Anything on behalf of the people for
Your Honor, I would just ask the court follow the recommendation in this matter. Thank you.
Mr. Truce?
Likewise, Your Honor, I think the recommendation here is appropriate. I think it is appropriate to give me the opportunity under 7411. I understand from Mr. Michelle's, I think the last 6 months to year has been a chaotic and difficult time for him. But I think he is working to kind of get his feet under him and take care of some of those issues. I know he has discussed with me his licensing issues as well, insofar as his contacts with, oh gosh, I'm sorry, I'm gonna forget the attorney's name, Todd Lovely, in regards to, taking steps to try to get his license back. From what I have seen, again, I think this represents an anomaly for him, and I think if given the opportunity, he will show you that this is not representative of his character. Thank you.
Mr. Michelle? What do you want to say?
Pretty good, you know. At time, yeah. That's
All right, well, I did review the report. I'm familiar with the circumstances that bring you before the court here today, along with your general background and circumstances. That's all in the report as well. And I do think that the recommendation is appropriate. It's going to give you an opportunity through probation, number one, to avoid any jail time. I'm going to impose some jail time to hold that in abeyance. So if you do successfully complete your probation, you won't ever have to serve that time. If you violate your probation or have other problems, then I can impose any or all of that jail time immediately. I mean, no hearings, nothing, right to jail. So I hope that that will provide an added motivation for you. But otherwise, if probation goes well, if you comply, then under 7411, you'll be able to have this come off the public record, which would be a benefit. So I hope that's the way it goes. Thank you. The court is going to place you on probation pursuant to 7411 for a period of 18 months. I am going to adopt as the conditions of that probation all the terms and conditions that are listed in the report. Of course, that includes that you not use or possess any controlled substances or drug paraphernalia, or to be with anybody who does have those items. So it's important for you to just stay away from that whole scene. The court is going to order that you serve 6 months in the Crawford County Jail. You do have credit for 2 days served. The court's going to hold that time in abeyance to be served at the discretion of the court. The crime victim's assessment of $130, court costs of $325, attorney fees of $350, the DNA testing fee of $60 per month while you're on probation.
There's no state house. I just want to add that up.
Oh, yes,
Yeah.
$68 state cost. Because this is pursuant to 7411, there are no appellate rights at this time. Ms. McGregor, is there anything else that you need to address?
No, I do believe there's an open warrant though, Your Honor.
Okay,
That is confirmed with district court, so you may want to
just go next door.
correct.
So, Mr. Michelle, before you leave court today, you could go to the clerk's window there and get that taken care of. Otherwise, somebody's going to chase after you. So, otherwise, good luck to you going forward. Thank you.
Thank you, Your Honor. Have a great day.
Are you Miss Nephew?
Yes, sir.
Oh, can we take Miss Nephew's case?
Yes.
Mr. Thompson, would you be ready on Miss Nephew's case?
Yes.
Okay, take that one out of order. Miss Nephew, if you want to come up to the podium here, please. We'll go on the record. People versus Corey Nephew, file number 255505. The record should reflect the staff who is present here in the courtroom today. If I could have counsel put your appearances on.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Jason Thompson, on behalf of the defendant, Corey Nephew.
This is the date set for sentencing in this matter. Ms. Nephew, have you had a chance to go through this pre-sentence report?
Yes, sir.
Mr. Thompson,
Yes, Your Honor.
do you need any more time to do that?
No, Your Honor.
Mr. Thompson, are there any additions, deletions, or corrections to that report?
No, Your Honor.
Are there any challenges to the scoring of the guidelines?
No, Your Honor.
Ms. Coe, do people have any additions, deletions, or corrections?
No,
Any challenges to the scoring?
no.
Anything on behalf of the people for allocution?
I really wish that Miss Nephew would get her act together. I realize addiction is a in and out cycle, but she's only 30 years old. She has 2 misdemeanors and 2 felonies. She was on bond and parole at the time of this. Her guidelines are 5 to 23. Has these high guidelines because of the circumstance she was in. This is, I think, maybe one of the first cases I've seen that send somebody back to prison for a violation. Her daughter was present at the time. I think the recommendation is appropriate. I hope that when she finishes her sentence, that we don't see her again. Thank you.
Mr. Thompson?
Thank you, Your Honor. Some of what's prosecuted is certainly accurate. Ms. Nephew has really struggled with addiction. To the point where when the court reviews, the background and the circumstances of what got us here, it doesn't make rational sense. These aren't, decisions that someone sits down and plots out. That's how they want their life to go. Ms. Nephew is a person who does have a lot of potential. She's very intelligent. She's got a real presence to her. She is very influential. She has a lot going for her. She has a daughter who she cares about very much. She has attended school and done well while she's attended. Ms. Nephew's continue to struggle with an addiction. It's the whole nature of the addiction is it's not rational. It doesn't respond to, hey, if you rationally thought about this, wouldn't it be better if you weren't using? She's been using, the court probably saw the family section in this PSI and kind of some of those circumstances provide some insight into what Ms. Nephew is dealing with. She is a person who's got a lot of support. She's got family members in the courtroom today. They're still here with her. They understand she's struggling with addiction, but they're trying to help her get to the other side of this. She's written out a plea, Your Honor. I think it's really well written, and I think it explains where she's coming from it and why she's asking the court to consider a 12-month sentence. Thank you.
Ms. Nephew?
Yes, Your Honor. I want to begin by taking full responsibility for my actions. I'm not here to make excuses, blame circumstances, or minimize what I did. I knew my behavior was wrong and chose to do it anyway. And that choice brought me here today, and I accept that. I also understand that this is not an isolated mistake. It is part of a pattern of poor decisions that allowed me to continue, or that I allowed to continue, even after I had already been given chances to do better. I failed to respect the law and opportunities I was given, and I failed people who depend on me. And that's something I have to live with, and it weighs on me every day. Being here has forced me to look at myself in a way I avoided for a long time. I see now how my choices have damaged my family, my future, and my credibility as a person who says they want to change. I understand that words alone do not fix it, only consistent actions over time will. I'm not asking the court to overlook what I did. I'm asking the court to consider who I'm capable of becoming if given a realistic opportunity to do the work required. I respectfully request a sentence of 12 months, not to escape accountability, but because I believe it's a sentence that balances punishment with the chances for real rehabilitation. I want to use this time to rebuild stability, take responsibility for my life, and prove through my actions that I can follow the law and live differently. I do not want to keep cycling through this system. I want this to be the point where things finally change. I assure the court that I will take this process seriously and that I do not take leniency for granted. I'm committed to doing better, not just saying it. Thank you for taking the time to listen to me today.
Thank you. Ms. Nephew, I did read through the report, so I'm familiar with all the information in there, including the circumstances that bring you before the court today, what your status was, all of that. And I've listened to what the lawyers had to say. I think what Mr. Thompson said is really right on. He's exactly right. This is a logical choice. This is something that I think your substance use disorder is driving you to do. And because, like you said, I don't think anybody, when they're on parole, they know that eyes are on them to go right back to using, possessing substances. It's just doesn't look like something somebody who's thinking correctly would do. It looks like something somebody who's desperate to get that urge taken care of. That's particularly with your daughter's involvement. It's just not something that somebody was thinking through. So I think he's exactly right in that assessment. I also listened really carefully to what you had to say, and I think if you can follow through with those things and wanting to change, now's the time to do that. But I also have to look at the complicating factors that we have here, and the reason why there's no jail credit when you do this on parole, and the extra penalties that you're facing. I can't just ignore those things. Those are there for a reason, and they're there to, as difficult as it might be to change somebody's behavior when they are in the throes of addiction, to at least try to provide some type of motivating factor to counteract that. And so I can't just ignore those things either. The sentence here is for 15 months. It's right in the middle of the guidelines. I think it's a fair sentence. I think it does account for your behavior while on parole and continuing to reoffend. But I also think it gets you out earlier than the sentence at the top of the guidelines would.
Yeah.
So I think it's appropriate. I think it does address everything that happened here, including the aggravating and mitigating factors. So I am going to follow the recommendation and sentence you to Department of Corrections for 15 months to 10 years. Because of the parole status, you have 0 days served. Crime victims assessment of $130, court costs of $325, attorney fees of $130, and $68 state costs. You do have the ability to seek an appeal of the sentence, Mr. Thompson.
There's 4 copies here. You initial the top one to acknowledge that you received it. You're going to take the bottom 2 copies and wish to appeal. Do it, fill those 2 out, and send them in. The first deadline is 14 days, so those are yours to keep.
Oh, is there anything further that?
No.
Mr. Thompson,
Nothing for today's program. Thank you.
good luck going forward.
Thank you, sir.
You can. All right. Also take.
Okay. Thank you.
Is Mr. Roten here? Go ahead, pronounce your name, sir.
Rogan?
Roten.
Yep, you're right.
This is file number 245286. The record should reflect Mr. Roten's presence here in the courtroom today. I've got counsel put your appearances on.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Richard Trish, appearing on behalf of Mr. Rowe. This is date and time for a arraignment on a probation violation. I've had an opportunity to talk to Mr. Roten about this, as well as the probation department. We would waive a formal reading of the allegation. We would stand mute to the charges. He has been approved for counsel. I was counsel in the underlying case, so I'll be appointed on that. And we would request a hearing be set about 60 days down the road. The anticipation is, if Mr. Roten satisfies the outstanding fines and costs, that it would be dismissed. And I would indicate that seems appropriate to me, given that this is really the only violation he has had. And again, it's just economics of getting paid.
Mr. Haven?
Yes, Your Honor, that is the same sentiment that Agent McFalda has relayed through me. Yeah, if we could have a set out to early April is what he had stated, so give him time to pay
I'm sorry. Go
and
ahead.
give him time to make payments.
Any objection to a PR bond?
No objection.
Okay, so Mr. Roten, it's important between now and April that, number one, that you stay in contact with Mr. Trush, your attorney, but also Mr. Haven. And hopefully we can get this resolved, and then it sounds like this may be dismissed. If not, then figure out how to go forward. From there, the court will enter a not guilty plea on your behalf for purposes of today's hearing and impose $500 personal recognizance bond with all standard terms and conditions, including all conditions of probation. sure you follow probationary terms. So, Mr. Roden, did you have any questions? No, sir. Rich, anything further?
No, Your Honor, thank you.
I'm sorry,
Did you say 60 days?
60 days.
All set?
Okay. Is Mr. Scarborough present?
Last I remember seeing a list in Ms. Dempsey's office that he was lodged in Wexford County. I don't know if it's the same person or not.
I think, is this another probation violation? Right?
Yes, it is, Your Honor. And last I knew, he had front of the court warrants, so that could be where he is and why he's there.
How did you want to proceed today?
Well, I didn't hear that he was lodged. If he is lodged, then I would just suggest an adjournment.
I think maybe rather than bench warrant and everything in the works, let's just reset this for 2 weeks.
Okay,
And then maybe you can see if you can find out if he is lodged.
okay. If that is the case, I will then refer it over to Agent McFalda.
Is Mr. Gilner present?
He's lodged, Your Honor.
Yes, okay. Now we got that on track. Let's take a short recess. We'll come back on the record as soon as we have Mr. Gilner. Mr. Thompson, have you had any luck with Mr.
Yeah, Mr. Ackerman, no. We'll tell the court, Mr.
the record in People versus Stephen Gildner, this is file number 251200, I'm sorry, 5450. Like that, comfortable with your appearances on.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Jason Thompson on behalf of defendant Stephen Gilbert.
Thank you. This is the date and time set for sentencing in this matter. Mr. Gildner, did you have a chance to go through the pre-sentence report and talk to Mr. Thompson about that?
Yes, sir.
Mr. Thompson, I did receive a support letter on behalf of Mr. Gildner from Sheila Detloff. Are there any other additional solutions or corrections?
I do have a correction. I believe we can agree on it, Your Honor. The pre-sentence investigative report puts the total days of jail credit at 126. In discussing that with Mr. Haven, I think we agreed that was some sort of computer or typographical error. And we recalculated 239.
That is correct, Your Honor.
Okay. So then I have any other additional solutions or corrections? No. Any challenges to the scoring of the guidelines?
No, Your Honor.
Ms. Cope, do the people have any additions, deletions, or corrections?
I asked Mr. Haven to update the front page under plea agreement. It has the district court number, just put the circuit court number that was dismissed. It's just a typo. No other changes.
Okay. And do you have any challenges to the scoring?
No,
Do you have any victims that wish to address the court today?
no.
Anything on behalf of the people for allocation?
Your Honor, I think at this time, Mr. Gildner has earned the top end of the guidelines with his behavior. He's 63, definitely old enough to know better at this point. 11 misdemeanors, 4 felonies. He's frankly lucky that this fire didn't get out of control and cause a lot more damage. I think the recommendation at the top end of the guidelines is appropriate, if not the 23 months. Thank you.
Mr. Thompson?
Thank you, Your Honor. Court's familiar with this matter and familiar with the pre-sentence investigation. Mr. Gildner has been a long-time member of this community. He does have support, not just the letter you received, but there's 3 individuals in the courtroom here to support him today. Mr. Gildner has struggled with alcohol during his life. That was part of what happened here. He really is a gentleman who, he's part of the community. He has people, he has associations here in this community. He really does benefit from those relationships. The charges are serious. This was a shed that belonged to Mr. Gildner. As it's noted in the PSI, there's not necessarily a good reason this even happened, that anyone can necessarily figure out. The circumstances of this, again, nobody ended up getting hurt. There was some property damage to the shed, which was his. This didn't spread and damage other properties. Mr. Gildner, I think the court's familiar, he was residing in that neighborhood back there that essentially got shut down. In the process, he lost his home. He's been on the wrong end of a lot of life circumstances like that. I do think, quite frankly, this time is going to be good for Mr. Gildner, and that he's going to get some health care. And I think he's got some real health needs that need addressing. I'm hopeful they're not as serious, but I'm concerned they might be serious. So I ask the court to consider a sentence at the low end of the guidelines on this. Again, looking at the nature of the offense, I don't think this is the most serious arson case the court's ever had. It's the most serious arson case the court's had today. I just ask the court to take all that into consideration. Thank you.
Thank you. Mr. Gildner, anything you wanted to say today?
No, sir.
Okay.
Sorry it all happened.
So, Mr. Gildner, I did review the pre-sentence report, so I'm familiar with all the information in that report. There's a very detailed description of what took place in this case, both with regard to the arson and the witness intimidation charge. And so I'm fully aware of all the factual circumstances that bring you before the court on these charges today. There's also a lot of information in there about you and your background and so forth. And so I take all of that into consideration along with what the lawyers have had to say as well, and trying to fashion an appropriate sentence. There are some things certainly working against you here, the nature of both of these crimes. which, luckily nobody was hurt or any other property damage, but that was something that certainly could have happened. I think the court has a very vested interest in discouraging behavior that does intimidate or prevent witnesses from making truthful statements or coming forward. Mr. Thompson's correct. This wasn't the most serious fire or burning your own property. So that is a bit of a mitigating factor here. And then we look at your past history, which is significant. You have quite a few convictions. You've been on probation a number of times in the past. Been on probation 7 times previously, 5 prior jail sentences. And then here we are, at your age of over 60 years old with more criminal charges. So balancing all of those things together, I think at this point, the court is warranted in imposing prison sentence. As to the witness intimidation charge, the court that calls for a prison sentence. The arson charge, the court could impose a community sanction, but prison sentence is what is called for. Intimidation charge. I do think because of the mitigating factors that the sentence in the middle of the guidelines for each is appropriate. And so the court is going to impose a sentence as to the arson charge of 23 months. Michigan Department of Corrections, that's 23 months and 10 years. On that charge, 239 days credit. A crime victim's assessment of $130, court costs of $325, attorney fees of $350, and a $68 state cost. As to the witness intimidation charge, the court is going to sentence you to 30 months to 15 years in the Michigan Department of Corrections. You also have 239 days credit on that charge and a $68 state cost. Both of those sentences to be served concurrent or with each other at the same time. You have the ability to seek an appeal of the sentence. Mr. Thompson, can you, Mr. Gilmer, acknowledge receipt from his appellate?
You're gonna initial this top copy, you're gonna leave 2 bottom copies. If you wanted to file an appeal, you would fill out one of those 2 bottom copies and have that written in. Your first deadline's in 14 days, so you should do it before that.
Ms. Cope, is there anything else we need to address on this file today?
No, thank you.
Thompson?
Just for today's record, I believe the other matter is being dismissed. I just wanted to put that on the record. Mr. Gilmer's other matter is part of this plea.
Ms. Cope, is that correct?
Yes.
All right, Mr. Gilder, you are admitted to the custody of the state at this time. Officer, okay. Mr. Vernon, were you ready on Mr. Woods' matter?
Yeah.
Mr. Woods, be coming forward to voting, please. We'll go on the record in People versus Woods. This is file number 235201. To reflect that Mr. Woods is present here in the courtroom today. Executive counsel here.
You're a program on behalf of the people.
And we're on behalf of Mr. Woods, president, am I right?
This is the date and time set for sentencing in this matter. Had an adequate opportunity to go through the pre-sentence report and speak to Mr. Vernon about that.
Yes, sir.
Mr. Vernon, are there any additions, deletions, or corrections to that?
So there are a couple of corrections, Your Honor. On the cover page, jail credit is identified as 14 days. With Mr. McFall sent out an email that identified that it should be 34.
Let's go.
No objection.
With regards to on that same page, identifies as pending charges. There's those events that's taking place in Knox County, Tennessee. I did my best to investigate that. It doesn't appear that they're new charges. It's the best information that I have. Again, I don't have anything that clarifies or is certain on that issue, but the best information I have, it appears that those are not pending charges. They are probation violations. That he was placed on probation and essentially that he came to Michigan and didn't respond to the requests to appear for probation if it's meetings.
Okay, so the pending charge should stay probation violation.
I believe that would be correct.
Underlying charges.
Yeah.
Ms. Coe?
I actually have no information, so I would defer to the court on that.
All right, we'll make that correction.
So what I would say then is that on the section beneath that under prior record, probation says active, it should say yes, I believe, as opposed to no, because we believe he was on probation at the time.
Any objection to that?
Again, I don't have any information since it's out of state. I'm unable to get that or confirm that.
All right, we'll change that to yes.
At least that way it's consistent. And then on the next section down under personal history, it identifies psychiatric history, no, but in the medical section of the PSI, it identifies that he has mental health problems. He has been previously diagnosed. And it was actually in a PSI that he had previously submitted to for depression and schizophrenia. And he had been prescribed medications in that schizophrenia evaluation. So we believe that psychiatric history should be marked yes.
Okay, I think that would be consistent with the narrative. Ms. Coe, any objection?
No objection.
Okay, we'll mark that as yes.
I believe that was it, Your Honor.
Are there any challenges to the scoring of the guy?
No.
No.
Ms. Coe, do the people have any additions, deletions, or corrections?
No.
Any challenges to the scoring?
No.
Anything on behalf of the people for allocation?
I was really surprised by this recommendation, given Mr. Woods, even just his history in this file in terms of absconding and not appearing and how long it took to get this case resolved. He's had multiple problems with probation and appearances in the past. I didn't do an objection, but 2 weeks ago, because PRV 15 or PRV 19 is already scored at 15, but I received a report 2 weeks ago that he was in a fight in the jail where he punched somebody in the face twice. But since he's already scored at 15, it doesn't add anything. He's just not a good candidate for jail. When you look at the circumstances which are outlined in the PSI, the behavior that he was in, as well as his criminal history, which includes prior plea and eludes, prior resist and obstruct. You know, he's 40 years old. He's got 12 prior misdemeanors and 6 prior felonies. I don't see why he would be at the low end of the guidelines, given his behavior throughout his criminal history, but also in this case as well. So I would ask the court to sentence him to 18 months. Thank you.
Mr. Byrne.
Your Honor, we would ask the court to follow the guidelines. The recommendation seems appropriate. The guidelines are 12 to 24 and 2 to 17 on the 2 counts. The offense took place back in 2023. And the reality is that, you know, Mr. Woods had actually at the time been working very hard to focus on his family and his reintegration into the community. It appears that he had actually been doing a fairly good job of doing that. And he'll explain to it a little bit more in depth from his perspective. But I think what happened is he just got nervous. He got scared. He made a poor choice. He had finally gotten, an opportunity to be heard in another court regarding parenting time. Finally got that parenting time reinstated, and he knew that if he got in trouble, that would all slip away from him again. And I think that just caused him to make poor choices. And this was clearly a poor choice. I don't think he's going to deny that. Fleeing and eluding and resistant obstructor, are serious offenses, and people can get hurt. And he knows that, and he is willing to accept the responsibility for that. I think a jail sentence is appropriate. We would ask the court to accept the recommendation and impose that with the other conditions that are set forth.
Mr. Woods, anything you wanted to say?
I do have something to say. I do definitely have something.
You don't have to lean forward, if you want to read your thing.
I don't know anything about fights or nothing like that, but I would like to explain to you, not excuse a little bit of myself and my history that would allow me to make the decision that I made, which led to me missing court, if you will.
Yeah, this is your time to say anything that you want to say, so absolutely.
I want to acknowledge this and accept accountability for my charge. I was wrong for what I did, and I allowed fear to take over, and I made a bad decision that I regret. Allow me to explain a little bit of my history to take them on. At 18 years old, I lost my first son, Desmond. I've been on my own in this world since I was 16. I was welcomed in by strangers. They were drug addicts. They were loving, but they were addicts. Things I never seen and thought I would do. Curious, I became a user myself. After birth, his mom disappeared and I felt my responsibility. I wish I was able to think and function as an adult back then because it hurts. My past history of violent behavior, I'm ashamed to admit, but I will. I was on hard drugs and in relationships, in and out of homes with others who did the same, which led me to jail. That sentence required me to complete a DV class where I had to admit to my drug use, accept accountability. I was taught responsibility, development skills, etc. I long stopped my usage, but my addictive behavior, I involved myself around those same type of people. And that class made me realize that I needed to change my way of thinking. After 8 months, I completed and graduated from that class. And this year marks 16 years sober, where I checked myself into outpatient treatment at NCADD in Detroit on Wyoming Street. I completed and I haven't looked back. This year, 2026, December 16th, my son will be 18 and hopes how long I've waited that I could have more resources and access to find him in an attempt to restore my relationship with him. Since I earned this charge that I regret, I now have 2 daughters. My 9-month-old daughter is safe at home, no issues, along with my stepkids. But prior to, my first daughter was born April 11, 2023. I got friend of the court involved, unsure I wanted the DNA testing. I never planned on being somebody's baby's daddy. When I chose to make a child, I planned on being in a home as mother and father, raising our kids together as a family, as it's supposed to be. She didn't want it. Soon we had a court date, May 2023, scheduled on Zoom. This is while I had this going. My responsibility as instructor was to provide proof of residency, transportation, work, etc. Weeks and months went by, no here, no mail, no paperwork, no nothing. Before I proceed, I've always respected this courtroom and my obligations. Sometimes our thinking isn't the best, but yet it's not our worst either. So I'm hoping that the people can understand from my loss of my son, vowing to never give up on my children, ever. I hope that the people understand when I miss court, if I may proceed. I had visitation rights every Sunday. Last we heard, because either of us had heard back from the court, but I'd have my daughter every day. I found out my kid's mother had some man around who I knew nothing about. My kid on that day, we exchanged words, and since November 13th, 2024, that was the last day I had seen my child. She would not let me see my child. I went down to front of the court, and after waiting, a man came back with vague news paperwork that was never sent out, and explained to me that paperwork was never sent out, but couldn't explain to me why. I filed a motion for child reinforcement, and I was granted parenting time, which I obviously had to give the court my address. August, September, October, November, no mail for my parenting time. I finally got a hold of the magistrate in December. That was the time I was supposed to come of the court, who admitted that the magistrate admitted that she had screwed up, or messed up rather. I was looked at as non-compliant, and my case was about to be closed out on the court's technicality. I was just getting my parenting time back, and I did not want to lose another child. Your Honor, I was always aware of my obligations to this courtroom, and I was troubled in spirit. I look for direction, but I'm not anointed enough to know God's spiritual direction. I confided with my dad, confided with my pastor, and the message was just keep doing what you're doing and God will fix it. And he did. Thankful Detroit Parenting Time has put my case on hold until my release. After the loss of my son, I was determined to always be in my kids' life and never give up. Always be a hero to my kids. So I want you to know, Judge, that I accept accountability and I apologize for missing court. To the prosecutor, I apologize. My charge, I will never do this again. I will never do anything to jeopardize my freedom and time lost for my children. I had one session with my daughter in January to complete 10 sessions by March. That way my rights would be restored and shared custody. I only seen my daughter one time since November 2024. And in that session, she fell asleep and I laid her down when it was over. I didn't want to wake her up to tell her goodbye. I just knew and know today that I'll see you later. 1 week later, I'm here. And again, I apologize. I would never do anything anywhere else. I've learned my lesson. A few years, I've learned my lesson. But in order to have peace in my life, I want to get this behind me in order to be the best father that I know that I can be. When I'm released, I will get my license. I will not drive again. Until I do, it's not worth it. I'm determined to honor the law. I will pay my fines at all costs. I will pay my restitution. I will continue my meds at mental health, at ACC mental health, where I was diagnosed. I realize the importance. I will find my son. I will continue my parenting time. I will not have no more kids. I will continue supporting my family. And most of all, I will not let this courtroom down. And I'm just asking for the court's mercy.
Right, thank you. Mr. Woods, I did read through the pre-sentence report, so I'm familiar with all the information in that report. It gives a description of your offense in this case and what took place during the plea, including that, your actions that bring it before the court here today. There's also a lot of information in there about you and your background, your circumstances. And certainly sorry for some of the things you've had to go through. It's difficult.
I apologize too.
It's difficult for a parent to go through that. And so I can certainly understand how that may have led you to do some things, or especially earlier on in your life. So there's a lot of information in that report though about you and your background, and I take all of that into consideration, including what you've had to say here today. I listened very carefully to everything you said, as well as what the lawyers have had to say. There's a couple of things that stand out to me about your case. Number one, this was a very dangerous incident. This wasn't a short, speed up, try to get away from the officers and then pull over. It resulted in, you essentially going down into a ditch with your car, getting out, and then running from the police. You put yourself at danger, you put the police in danger, you put everybody else, innocent people who had nothing to do with you or your situation on the road, in danger during the course of this incident. The other thing that struck me was just your prior history. You've got 12 prior misdemeanors, 6 prior felonies. You've been on probation 10 times. You've been to jail 7 previous times. And so none of those things have changed your behavior. You had a fleeing and eluding in this case. You had numerous assaultive offenses. You had a fleeing and eluding in Hazel Park back in 2022. So this isn't even the first time that you've engaged in this kind of behavior. So I don't really accept that this was a spur of the moment bad decision, because you've done it before and you should have learned from the previous time that you have to run from the police. It's not going to get you anywhere. So when I look at all of that, I really don't see it, as well as just all the prior jail sentences and probation sentences. I really don't see any reason why the court should go below a prison sentence in this case. I think you've earned it with your prior history. I think you earned it with your conduct here. So I don't find any of the things that you talked about, which are legitimate things, but I don't find that any of them are enough to mitigate gone on here in this case and all your previous offenses. So the court is going to sentence you as to the fleeing and eluding charge. The court is going to sentence you to 24 months to 5 years. In the Michigan Department of Corrections, you have credit for 34 days served. The court is going to order a crime victims assessment of $130, court costs of $325, attorney fees of $350, and a $68 state cost. On the resisting or obstructing offense, the court is going to sentence you to 12 months in the Crawford County Jail, again with 34 days served, $68 state cost. Those charges to be served concurrent to each other. You do have the ability to seek an appeal of the sentence. Mr. Vernon, can provide those appellate rights.
You signed the original receipt that provided the court 2 copies of the letter of appellate review or provided to Mr. Woods, 1 copy to the prosecutor.
Mr. Woods, you are remanded to the state at this time.
So he sentenced for 24 months.
Is Mr. Peel present?
Yes.
Mr. Peel, if you come up to the podium, please. On record in Peel versus Peel, this is file number 2512007. The record should reflect Mr. Peel's present here in court for today. If I could have counsel for your appearance.
Sierra Cook, on behalf of Ms. Peel.
Thank you, Honor. Jason Thompson on behalf of Defendant Brandon Peel.
All right, this is the date and time set for a sentencing hearing in this matter. And Ms. Koch, I did receive a letter from Kathy Peel. Are you here, Kathy?
Yes.
And so I don't know, Ms. Peel, did you want to make a statement here today as well?
No, that says it all.
No. So Ms. Koch, is there anything you wanted to say on behalf of the people here?
No, the court's familiar with the background and they've heard from Ms. Peel. Thank you.
Mr. Thompson?
Thank you, Honor. I've been representing Mr. Peel. He's a really likable, he's a really hardworking guy. He has these issues that come up before, as the court is aware, where he is very, emotionally connected to his family. These personal protection orders are entered. And Mr. Peel finds us in circumstances where someone in the family is inviting him to part of the property or to talk to him. And he's the one who, ultimately violates the PPO and ultimately has to pay the price for this. Brandon's a person with some significant mental health needs, and this has prompted him to be getting treatment at CMH. I talked to him, he's seeing a therapist every other week, then he's seeing his case manager every other week. So he's seeing somebody weekly. He's taking a different job to hopefully accommodate his need to go to that CMH type of treatment more often. He had a job that was, not receptive to him taking time off. He's going back on our works. He's working, 4 or 5 times a week. Brandon is a really kind of dedicated person, and when he starts working, he works a lot. He works overtime. Sometimes he runs himself, a little too hard, and he's got to learn how to balance his life and how to do a better job of being sort of emotionally self-reliant, so he's not, feeling compelled that he has to break PPOs when he wants sort of that family support that we all kind of understand how a person can break. I do think this is the kind of case where if the court can order him to continue the CMH treatment, that's the most important thing. That would really help Brandon. So that's what I'm asking the court to do. Thank you.
Thank you, Mr. Peel. Anything you wanted to say today?
I apologize for the courts for my PPO violations. I am working, new job, and it's going good right now.
So I'm familiar with the case, Mr. Peel. I understand kind of what happened here, as well as the circumstances of the underlying personal protection order. There's a couple different ways that the court can punish wrongful conduct. The court can punish it by, of course, putting somebody in jail. court can also punish wrongful conduct by imposing a financial penalty. In this case, given all the circumstances, given what Ms. Beal had to say in her letter, I find that that a financial penalty is appropriate here. A PPO, the court is kind of limited to contempt sanctions, fines, and or incarceration. So I certainly agree with Mr. Thompson that continued treatment, therapy, and counseling would be beneficial to you and should keep doing. I don't think I have the jurisdiction to order that as part of a PPO sentence. But I certainly would encourage you to continue doing that because that's going to prevent you from being back in this room again where I don't think you want to be. So the court is going to impose a $250 fine and $100 court costs for the violation here. You do have the ability to seek an appeal of the sentence. If you wanted to do that, you would need to file that paperwork within the next 21 days. If you have questions about that, Mr. Thompson will be able to answer that for you. Otherwise, Mr. Peel, I just want to impress upon you that the PPO is still in place, that you need to continue to abide by all the provisions of that PPO and not have any contact, okay? Do you have any questions?
Yes, about the DPO, that's at my grandmother's house, right?
Well, let's see. I'm sure, Mr. Thompson, maybe you want to go through it with them in a little more detail, but it prohibits you from being on the property at 2504 West Jones Lake.
Oh, all right.
But it also prohibits you from appearing or being within sight of Kathy, sending any mail or communications to her, approaching or confronting her in a public place or on private property, appearing at her workplace or residence. So just make sure you go through that order. Do you have a copy of that?
I believe it do, yes.
Okay. You want to read that and make sure that you understand that. And again, if you have questions, Mr. Thompson, like that too, okay? Mr. Thompson, anything else you need to address?
No, for today's record. Thank you.
Let's go.
Thank you.
Okay. So Mr. Peel, I'm just going to ask that you have a seat there on the bench just for a few minutes. Let Ms. Peel and her parties exit the courtroom. And then once they're gone, you need to check in with the clerk's office to make arrangements. Okay, the fines and costs. Okay.
All right.
Thank you.
And if you need another copy of that. Here we go. No, I knew it was
Ms. Moore, Your Honor.
Were you ready with that, please? Yes. Okay, Ms. Moore, come on up to the podium, please. We'll go on the record, People versus Tammy Moore. So this file number 5490, the record reflects Ms. Moore's presence here in the courtroom today. This is the date and time set for sentencing.
Get through there.
Ms. Moore, have you had an opportunity to go through the pre-sentence report and talk to Mr. Thompson about that?
Just a little bit.
Do you need more time to do that?
Yeah.
Okay. Take a short break. Mr. Thompson, once you're done, just let Sarah know. All right, we're back on the record, in People versus Moore. And Ms. Moore, have you now had a chance to talk to Mr. Thompson? Mr. Thompson, are there any additions, deletions, or corrections?
You may need to update the jail credit on this, Your Honor. I think she should be 16 days at this point, was to originally. I come up with 18, I don't know what.
Your Honor, Mr. McFarland has 19 days.
Okay, I'll take that.
Okay. All right, so we'll correct the report to reflect 19 days of credit. Are there any other corrections?
Your Honor, my client just advised me that she didn't qualify for Social Security disability.
Okay. Objection to that change in scope?
No.
Okay, we'll add that in there.
And that would be it.
Okay. Are there any challenges to the scoring of the guidelines?
No.
Ms. Koch, any additions, deletions, or corrections?
No.
Any challenges to the scoring?
No.
Anybody that would like to address the board today?
No, the restitution request was made and ready, and that was no other victim.
Anything on behalf of the people?
You know, Miss Moore, I never heard from her, and then I just heard from her repeatedly for months. Her blood alcohol was always very, very high. She's 47. She has 19 misdemeanors and 7 felonies. It indicates she has an active probation. That being said, she went to rehab. I don't know whether she completed it. I think she may have left early. I'm not positive how that worked out, but she was in rehab, so that was good. She had repeated drunken disorderlies throughout this community that ended up leading to where we are today. I think the recommendation is appropriate, and I would ask the court to follow it. Thank you.
Thank you, Your Honor. Yes, I spoke about this with Ms. Moore. She thinks she really did get a lot from the rehab program she attended in Saginaw. So she attended and graduated from a rehab program.
You're gonna get a chance here in a second.
And then she was released to more of a sober living, halfway house type of arrangement. And that's the facility that she was in, and that ultimately she left. She has a daughter who has a child now. That's going to be her residence when she gets out from whatever sentence the court imposes. She reports to me that her daughters are a really good influence, that her daughter is willing to set boundaries with her and only let her continue to be in that position in the house and helping take care of her granddaughter if she does remain sober. And she advises me she is currently sober and she has been sober. She advises that she was attending NA and AA when she was in rehab, and that she looks forward to using that as part of her recovery strategy. She has a recovery coach that she remains in touch with. And again, she is hopeful that her daughter Justina, by setting those boundaries and holding her accountable, can be a good influence that helps her maintain her sobriety. She understands that's going to be the whole ballgame here. I mean, when you look at the numbers she was blowing on some of these police reports, you know, she's just out in the community at 0.22 levels like that. I mean, Ms. Moore is a tiny person. That kind of alcohol is just very dangerous. And, you know, I'm very worried about her health if that were to ever happen again, but she assures me she's committed to maintaining her sobriety. And so ask the court to consider all that in its sentence. Thank you.
All right, Ms. Moore, anything you wanted to say today?
I haven't drank ever since I got out of the rehab. And I've been taking care of my grandson. When I went, they blew and I didn't, I wasn't, I blew, no, I wasn't drinking. I've been sober ever since I got out. I chose to go to rehab on my own. Well, they said I had to come and blow every day, but that was a little bit too much for me. And I'm glad that I did go there because now I got my disability and I can help my daughter now and I can stay sober. And I'm getting older, I'm tired, and I'm very tired. And I have epilepsy, so I can't do it anymore.
Yeah.
And now I can see sober and I can pay my fines, and you will never see me again in this predicament.
Okay, well,
And I don't want, to lose my disability, because I will. If I get locked up in prison, I will lose it. And it took forever to get it back.
anything else that you wanted to say?
And I truly apologize. It just the way that I grew up, and I just want to make a difference. I don't, I want to make a difference in other people's lives and tell them if I quit, I know that they can do it too. It's been hard. Maybe I can be a role model for somebody else.
Well, I read through the report, so I'm familiar with what happened in this case. I'm also familiar with your background and history from all the information in that report.
From drinking. Yeah.
Yeah.
Just let him go ahead, don't interrupt him.
Oh,
Yeah, it's not really dialogue. You have a chance to say what you want, and then it's my turn to say what I have to say. So I read through all of that, and I've listened to what you had to say very carefully, and what the lawyers had to say. And I was shocked when I read through your history, your criminal history. The number of assaultive offenses was, surprising to me. And even right up till fairly recently. And you've spent a lot of time, been on probation 6 different times. You've had 14 prior jail sentences and 2 prior prison sentences. So this has been a long-running, long-standing issue. And so, while this incident in and of itself, although it sounds like from what I read in the report that, you were kicking the police officer here and physically resisting, it doesn't look like from the report that there were injuries to the officer, but there certainly could have been based on the way that you were acting with the blood alcohol of 0.21. And so both your behavior in this case and certainly your past history, I think would warrant a sentence, and the guidelines call for a sentence of up to 23 months in prison. So, and I think everything about what happened here and your past history wouldn't be unreasonable to impose that kind of sentence. It sounds like you're doing some good work right now to deal with this, and it's never too late. And so I hope that you're going to continue to work on this, because if not, you're going to go back to prison. That's all there is to it. There won't be any reason to not do it. I think in this case, anything other than a prison sentence is a substantial break to you. Minimum on the obstruction charge is 5 months. That's the 5 months to 23 months. So the court is going to sentence you primarily because there weren't any injuries to the officer in this case. The court is going to sentence you to 9 months in the Crawford County Jail on that charge. Again, I think your behavior in this circumstance is more than warrants it. I think your history of assault offense is more than warrants it. For 19 days served. The court is going to order a crime victim's assessment of $130, court costs of $325, attorney fees $50, an assessment fee of $60 and $68 state cost. On the retail fraud charge, 30 days in the Crawford County Jail with credit for 19 days served. restitution of $19.39 payable to the Crawford County Clerk to be dispersed to Marathon Gas Station. $50 state cost, those sentences to be served concurrent to each other. You do have the ability to seek an appeal of this sentence. Mr. Thompson, can you provide those rights? Mr. Thompson, can you give me some papers that explain to you what your appellate rights are, Ms. Moore, as well as how to request a court appointed attorney to help you with the appeal?
You're gonna initial this top one, we'll give it back to the court. You're gonna get to keep the bottom 2 copies. If you wanted to file an appeal, let's go right here. If you wanted to file an appeal of the court sentence or your conviction, so you initial right there. Give that back to the court to say you got it. The other, you keep 2 copies. If you wanted to file an appeal, you would fill out this part and turn it in. The first deadline's in 14 days.
We have Mr. Ledesma present. All Ledesma versus State. 511875. Section 340 is now 340, or sorry, 330 is now 342. This was,
I do not see Ms. Ledesma.
And I don't think this PPO was ever served, Your Honor.
okay.
I could be wrong because I don't get the court file, but I don't have any documents that showed it was ever served.
So the court set this for a show cause based on a police report that was filed that came to the court where there was some alleged contact between is it Mr.?
It's Mr. Fitch and Miss Ledesma.
Petitioner, is that, you know?
Yes, August.
My nephew's name is August. I thought it was a male name, but I couldn't. Okay, so Miss Ledesma. No, it does not appear. Do you have any records?
No, Judge, so the PPO was granted, petitioner picked up the paperwork, never had it served, and then I got the show cause of violation of a PPO, sent it to your office, and then was set for today.
All right, so Ms. Cope, will you take any position on how the court should proceed?
I would ask that it be dismissed until it's served.
Okay, I think that's appropriate, given that the PPO was never served. Well, and it's gonna expire here, it looks like. Another month and a half, so. All right.
4-9.
So we'll dismiss the show cause and the court won't proceed any further on that. That's 3:45.
Revisit Ackerman.
What?
Just give them
Did you want to revisit Ackerman? Or is that-
He didn't appear. Your Honor, do we need to revisit Mr. Ackerman? I can't remember if the court.
Oh, yeah, I'm sorry. Forgot all about it. Let's recall people versus Ackerman. Mr. Thompson, do you have any luck?
No, my staff attempted to call him at the phone number he confirmed this morning. We checked Vine Link, which doesn't always update automatically. But we didn't see him either. We didn't see him in a jail. I don't have an answer for the court. The court heard my earlier comments, so that's all I know.
Okay. Ms. Pope or Mr. Hayden?
No, Mr. McFarland was, prepared to go forward with a plea on the violation, so leave it to the court's discretion.
Yeah, I will confirm we had a plea set up for today.
Mr. Haven, I guess I'm just gonna ask that you let Mr. McFarland requesting that you issue an warrant for Ackerman He had previously absconded since October and was recently arrested. So I have some serious concerns with the fact that he can't, here today, even in light of the fact that he has had contact with counsel. So I'd like to do a bench warrant for a probation violation for his family to appear here as ordered by the court. And then we'll proceed further once we arrest Mr. Ackerman and have him in custody. Anything else in that, Mr. Thompson?
Nothing further.
Okay.
Nothing further. Thank you for revisiting that.
I gotta say for the record, Mr. David, this is your last day in court, so.
Yes, sir.
I didn't have anything prepared, but I knew you were gonna be retiring. I didn't know today was gonna be your last day, so. I just want to thank you here on the record for your service to the court and the community. I've worked with you for the last 13 years that I've been on the bench, and I've always appreciated your professionalism in court, your professionalism out of court, the way you've always been prepared, ready with good recommendations for me, especially when I first started. It was important for me to have experienced agents with objective opinions. And over the years, I found you to be an incredible asset to the court. And you're going to be missed.
Well, thank you.
You certainly deserve everything that you've earned through retirement. I hope you have a wonderful
I appreciate
away
all
from
the,
court.
And we're all jealous.
I appreciate all the guidance and direction you gave me when I have questions, and that's appreciated. I've learned a lot in this job. It's like, much different than working in prison, so.
So congratulations.
Thank you.
And, I'm sure we'll see you at your gathering, and I don't want you to say too much on the record. But I do want to congratulate you on your long service and thank you for that.
You're welcome.
Yeah, support.
Thanks.
All right. And you have our last case. Okay, Mr. White, are you able to hear me okay?
I can hear you. Can you hear me, Judge?
Yes, thank you. And Mr. Dick?
Yes, Your Honor. I hear you clearly.
All right, we're gonna go on the record now in People versus Lawrence Baumgart, file number 255453, and Raymond Matthew, file number 255454. I requested this hearing for counsel today just to make a disclosure. It's an odd situation. It's one I've never encountered in 13 years on the bench.
Your Honor,
yeah.
if I may interject, you just said for counsel. I apologize. I did have Mr. Matthew appear. I don't know if this is him on the fun phone. I think he was borrowing somebody's phone to be here. But if it was just intended for counsel, I just wanted the court to be aware that he was likely present.
No, I mean, your clients are more than welcome to be present, but it's not something that's going to require their participation. Again, it's more in line. It's a disclosure by me to all counsel. And it's interesting throughout the case, your clients have been in court with me a number of times prior to trial, and then of course during trial. And throughout those times, I always felt like both your clients looked familiar to me somehow, but I could not place how they were familiar to me. And so we went through the trial, and it was something that was stuck in my head, and I more or less had just dismissed it as they had familiar looking faces, or maybe I had encountered them in the community, through a community event or something somehow at some point. And then the night after trial, I was laying there and I wasn't even thinking about this case, but then it popped into my head and I recognized where I recognized your clients from, and Mr. Baumgart had purchased a vehicle from me. I had listed my old truck on Facebook Marketplace because it wasn't running, so I was just looking for someone who wanted to get it for scrap. I think Mr. Baumgart engages in that kind of business. And so I finally, something clicked in my brain, and it hit me that that's where I knew. And Mr. Baumgart came to my home to purchase a truck, and he loaded it up on a flatbed, and Mr. Matthew was the one who helped him. And I had a very pleasant hour-long probably conversation with the two of them. And then I had to get some more additional documentation to Mr. Baumgart for the title for the truck. And I had his name and address written down in my records. So after it dawned on me, I went and just double checked my records to make sure that that's who it was, and that it was Mr. Baumgart. So I wanted to disclose that prior contact and prior relationship, business relationship, with all counsel. I didn't realize it until after the trial, so I don't know that it would be a basis for disqualification or anything that happened leading up to the point that I recognized both of those individuals. But I do think that I am going to disqualify myself from the sentencing hearing, because following the conviction and hearing the evidence that I heard, of course, not having a PSI yet or anything, I had already formed some thoughts about what I thought an appropriate sentence might be. And then having realized how I knew both of these gentlemen, and having had a very positive business dealing with them and positive personal experience in the short period of time that I did talk to them. And again, I should mention that I think I sold this truck to them maybe 2 springs ago. It's been several years.
That was my question, is the timing.
Yeah, it's been several years. And again, it was maybe an hour's interaction. So frankly, I'm surprised I even did figure out where I knew them from, because it had been so brief. But even in the amount of time I had developed a very positive attitude of both of them through the course of my interactions outside of court. And in my view, that prior personal experience with them is going to affect how I might sentence them. And so I don't think it's appropriate for me to preside over a sentencing hearing where I'm going to be potentially taking into account personal experience and personal knowledge that I have of the individuals that I'm sentencing. So the purpose for this hearing today is twofold. Again, to disclose that prior contact to everyone, and when I realized that there was something to disclose, the nature of those contacts, and then the fact that I'm going to disqualify for sentencing. All of that being said, Mr. White, is there any record that you want to make here today?
No, I just wish if you had a positive impact, you felt you could sentence them, but I believe your recusal is probably appropriate, and I'm not going to object to it.
All right, thank you, Mr. Dick.
Nothing from me, Your Honor.
Had I learned of this and the court hadn't made a decision, I would not have asked the court to recuse themselves, even with a positive. Frankly, we live in a small community. I know a lot of the people I prosecute, but I don't have any objection to however the court wants to handle it.
Yeah, and I certainly don't take disqualifying myself lightly. The court has an obligation to sit unless there is a valid reason. If it was, a casual community contact, maybe I wouldn't, but yeah, in this case, I think it's more appropriate. So I'm going to be entering that order so counsel can look for that, and then whatever judge is assigned will be scheduling and presiding over the sentencing. Any further questions about that can be directed to my office, and Jennifer can help with that. But otherwise, that's all I have for the record. Thank you, counsel, and everyone's free to disconnect.
Thank you.
Thank you, Judge.
Thank you.
That concludes our afternoon docket. We can recess.